Great. Good morning, and thank you for joining us today for an update on legislative changes to data practices and the open meeting law that were made during the 2025 legislative session. We'll also have a quick data practices potpourri at the end, highlighting recent questions received by our office. And about our office, the Data Practices Office is a small office in the Department of Administration, and we're a statewide resource on data practices and the open meeting law, both for members of the public as well as government. We perform a variety of functions that are listed here. Okay, if you would like to download a copy of the PowerPoint right now, I am going to share a file for you to download and save to your computer. A pop-up window will appear, and then you can select the file and download it to your device. So bear with me here just a minute while I share the file. Okay, this file is shared, and I will also share it again near the end of the webinar for anyone who joins us late or just misses this download this time around. And I know some attendees have had issues with downloading the PowerPoint via this function. Unfortunately, WebEx functionality can differ for each user. So if you have had issues downloading, please visit our website. This PowerPoint is posted on the webinars webpage where you registered for this webinar. So you can just visit that and download a copy there as well. So just scroll down to the bottom of that website and you'll see a link under Other Data Practices Webinars. Okay. So here is our plan for the morning. First, I'm going to cover data practices and open meeting law legislative changes from this most recent 2025 legislative session. Then I'm going to spend just a little bit of time highlighting some recent questions the Data Practices Office has received, with some time at the end for Q&A. So for the Q&A, please feel free to send in your questions as you think of them using the Q&A panel on your screen. Just make sure if you do that to choose all panelists when you send in your questions so that we can be sure to see them. And please feel free to start sending in your questions now, or you can also wait until the end of the presentation. So I'll begin by reviewing some of the changes the legislature made to data practices and the open meeting law, including amendments to existing provisions, as well as the creation of some new requirements for government entities. And as we're going through these changes, I will be citing the statutory sections that have been amended or added. If you would like the specific citations to the session laws that made these changes, I highly encourage you to look at the newsletter my office sent out earlier this month. And if you don't receive our newsletter, you can sign up and access those archives by visiting our website and selecting the subscribe to our newsletter box on the main page. I will also have a link to that page on our website at the very end of these slides. And just a final note, today is July 15th, 2025. Most of these changes went into effect this past July 1st, meaning that the changes are in place now. However, I will note any different effective dates that you need to know in order to comply with the law. Just another thing I want to note before I dive in is that I will not be covering all bills related to data practices and the open meeting law that were passed in the 2025 legislative session. There were many specific provisions that were passed this session that may only be relevant to a very small number of you. Some examples of specific language are listed here, but again, even this list is not comprehensive. So if a bill passed specific to your agency or your area and you would like to talk about it, of course, please feel free to contact us and reach out. We're happy to do that. But for today, I'm just going to focus on changes that impacted a large number of government entities and public bodies. So let's get started. The first change I want to mention will apply to all government entities under the Data Practices Act, and this is in addition to Minnesota Statute Section 13.03. So a new section in Subdivision 3 states that government entities may stop responding to a request if the data requester has not collected copies or gone in to inspect data within 5 business days. So this provision would come into play if you have a large request and you are working on responding by providing batches of data at different times. So let's say you make a portion of the data available to the requester to inspect, but they never come in. So under this language, you are not obligated to continue working on this request if the requester does not come in to inspect within 5 business days. However, if that requester does follow up with you and inspects the data or pays for the copies, then your obligation picks up again to continue the rest of the request. If you already have language on suspending requests in your policies, you can consider whether you would like to update it to reflect this new time frame from the statute. We do encourage all entities to have information on this process in your policies so that requesters can understand their rights and obligations when it comes to picking up or paying for their data. Next is a change to Minnesota Statutes 13.43, specifically subdivision 2E. So under this statute, data about employees of government entities are classified as private unless explicitly called out as public data in this section. When an employee is disciplined, some data about them become public. But if an employee is considered a public official under this section, then even more data about that employee are public if the employee is disciplined or if they resign while a complaint or charge against them is pending. So in this session, the legislature expanded the definition of public officials so that more employees are going to fall under this definition and have more data about them public should they be disciplined or resign. So first, there used to be population limits in this definition. So previously, only cities with a population over 7,500 people or counties with a population of more than 5,000 would have public officials. But these population limits are now gone, meaning that smaller cities and counties will have public officials under this new definition. And additionally, the legislature expanded this definition to include various employees of the Metropolitan Council. All right, moving on to educational data. So under Minnesota statute section 13.32, education data on students and their parents are classified as private. However, schools may designate certain data as directory information, and then those directory information become public. Schools must provide notice to parents and students of the right to refuse to let the school designate data as directory information. So in 2023, the legislature updated this provision to prohibit schools from designating a student's home address, telephone number, email address, or other personal contact information as directory information. Now, the legislature has added additional language prohibiting schools from designating the same information on the parents as directory information. So now a parent's address, telephone number, email address, or other personal contact information may also not be designated as public directory information. So these data just remain private. There was an additional change to this provision, however, that allows for sharing this private data with the Minnesota Department of Employment and Economic Development in order to coordinate services to students with disabilities. And just to note that this directory information change went into effect on May 24th, 2025. All right. Next, we have changes to Minnesota Statute Section 13.04, Subdivision 4, which details the process for individuals to challenge the accuracy or completeness of data about themselves. So under this provision, data subjects may challenge the accuracy or completeness of data about themselves to the government entity that maintains that data. That government entity must respond to that challenge within 30 days. And then if the data subject disagrees with the government entity's response to that challenge, they may appeal that response to my commissioner, the Commissioner of Administration. And then once the Commissioner of Administration receives that appeal, she tries to resolve this matter informally before sending the appeal to the Office of Administrative Hearings, or now called the Court of Administrative Hearings, for a contested case hearing. So a few changes were passed this recent session to protect some data received by the Commissioner as part of this appeal process. So first, government entities may share private data with the Commissioner in order to respond to a data subject's appeal. So previously, there was no sharing authority. So government entities were more limited in what they could share or say as part of that informal resolution process. If data are shared by the government entity that have a private classification, that classification travels and the data remain private at my agency. Additionally, if a data subject submits data to the Commissioner as part of their appeal, that data will have the same classification at my agency as they would at the entity that maintains the data being challenged. So for example, if someone wanted to appeal the accuracy of health records maintained by the Department of Corrections, they would need to send a copy of those health records to my commissioner. But those records would have been public at my agency as there is no statutory classification. Now, the records maintain the same classification as they do at the Department of Corrections. This provides protections to data subjects who may otherwise be wary of appealing the accuracy and completeness of private data about themselves as it would have become public at my agency. And finally, last but not least, if a data subject appeals an entity's determination that data about themselves are accurate and complete, and the entity agrees to update or destroy data as part of that informal resolution process, that old incorrect data that are maintained by my office are now just classified as private. And this is just to prevent the further dissemination of inaccurate or incomplete data. So if you have any questions about these data challenge appeals changes, please feel free to reach out to our office. We're more than happy to discuss them. All right. The next change is a change to access in body camera data. So under Minnesota Statute Section 13.825, inactive body camera data are only available to data subjects, and data subjects are individuals who can be seen or heard in the footage. But this new change provides increased access to footage used in collision investigations. Individuals who are entitled to a state crash accident report may now access unredacted body camera footage under the new 13.825 subdivision 4C in order to process a claim related to the collision or to use as evidence in a proceeding related to the collision. So under this provision, they are entitled to unredacted footage for these purposes, even if the investigation is still active. If the requester uses this body camera footage, though, for any other purpose, they may be liable for remedies and penalties under Section 13.08. Any law enforcement agency providing such access must notify the requester that the penalties and remedies under Section 13.08 will apply if those data are used for reasons other than processing those claims or evidence in proceedings related to the collision. And additionally, if law enforcement has an active investigation, they may withhold the data from the requester if there is a compelling reason access would interfere with this active investigation, if the data are clearly offensive to common sensibilities, or if the data have a not public classification under a different provision. So if law enforcement withholds this data for one of those reasons, they are required to provide a prompt written response for that denial and provide the requester a notice that they may seek relief under Minnesota Statutes 13.82 subdivision 7, which provides a mechanism to seek active investigative data in district court. And just to note that the State Patrol are not subject to these new access provisions. So if you are seeking data under this change, you would need to request the footage from local law enforcement. So some of you may remember that last year, the legislature passed a bill protecting the personal information of judicial officials. This protection requires the judicial official send a government entity written notice in order to protect that personal information, and it also included some takedown provisions to request removal of publicly posted information. Those protections for personal information did not include property records. So this legislative session, new language was introduced to do just that. So the law this year classifies personal information on judicial officials in real property records as private data on individuals. And real property carries the definition from the Safe at Home statute, Minnesota Statute Section 13.045, which states that real property records are any record of data maintained as part of the county real estate document recording system for use by the public, data on assessments, data on real or personal property taxation, and other data on real property. This also includes UCC filings and tax liens filed at the Secretary of State's office and any other records held by the county recorder or other government entities that show the title to, lien, judgment, or other encumbrance on real or personal property. So these new real property protections are likely to impact counties, right? But any government entity maintaining data that includes information on property ownership of judicial officials should probably be aware of these new protections. One big distinction between the bill passed last year protecting judicial officials' personal information and the bill this year protecting personal information and real property records is that the term judicial official is different. So for real property records, it is more narrow and only includes Minnesota District Court judges, Court of Appeals judges, federal judges, Supreme Court justices, judicial referees and magistrate judges, as well as any of their spouses, domestic partners, and children. So for this private classification to apply to personal information and real property records, the judicial official must send a written notice to the county recorder where the real property is located, as well as the office of the Secretary of State. For protections to apply to other records maintained by another government entity, this notice also has to be sent to that government entity's responsible authority. And just note that if those personal information requiring protection are the personal information of the spouse, the domestic partner, or the adult child of a judicial official, then that spouse, domestic partner, or adult child would be the one to submit this written notification themselves. That notification does have to be notarized in order to verify their relationship to the judicial official. So if you receive a written notification, you have 60 days to process the request. And then the classification in Minnesota Statute Section 480.50 applies to your data, as well as the remedies and obligations in the Data Practices Act. So just watch out for these notices, since that will be the trigger for the classification and for your compliance. The effective date for this law is January 1st, 2026, so it's not quite in place yet. And if you have questions about how this classification might interact with your data, please, of course, feel free to reach out to our office. Preventing fraud in public programs was a real focus of the past legislative session. And as a result, we have multiple provisions that provide for sharing of data in order to combat fraud or abuse in government. So the first is right within the Data Practices Act in a new section 13.357. So this section provides that government entities may disclose data related to suspected or confirmed fraud to any other government entity if providing that data would promote the protection of public resources, promote the integrity of public programs, or aid in the law enforcement process. So under this provision, government entities now have, broad discretionary authority to share data related to suspected or confirmed fraud if they believe that the sharing would assist with these goals. For state level entities, there are additional sharing provisions related to fraud data. So first, in Minnesota Statute Section 299C.061, state agencies that make either a mandatory or discretionary referral to the BCA's Financial Crimes and Fraud section now have clear authority to share any data related to the suspected fraud, regardless of the classification. And additionally, in Minnesota Statute Section 15.013, data related to fraud at state agencies now has a confidential or protected non-public classification, but this section provides for sharing to federal, state, or local government agencies or local law enforcement if such sharing would help prevent fraud or aid in the law enforcement process. All right, so just to recap, so through these changes, government entities have discretionary authority to share data related to fraud to different types of agencies depending on the concern and the report processes that are in place. So please also note that additional sharing for fraud data for specific programs may also have been introduced in subject-specific statutes. So I would definitely consult all the provisions mentioned as well as your agency-specific statutes, if applicable, just to determine how to share data related to suspected or actual fraud at your entity. Another provision specific to state level entities is in Minnesota Statute Section 16C.05. So this relates to contracting. A new subdivision states that any contracts entered into by the state shall not contain terms that are inconsistent with Chapter 13. So previously, any provisions inconsistent with Chapter 13, such as a non-disclosure clause involving public data, would not be enforceable. But now such provisions are explicitly prohibited for state-level entities. If you are not a state-level entity, we would still not encourage any provisions that are contrary to the Data Practices Act, such as provisions to not disclose otherwise public data, as those provisions are contrary to the law and unenforceable. We do have an advisory opinion discussing this. So for more information, you can see our advisory opinion 22-006. For our last legislative change I'll discuss today, I'm going to shift to the open meeting law, where we have a change that will impact all local public bodies. So these non-state level public bodies may conduct a meeting using interactive technology under Minnesota statute section 13D.02. So under that statute, those public bodies may hold remote meetings as long as certain requirements are met. And one of these requirements was changed this legislative session. So previously, if a member wanted to attend remotely, they had to notice the location where they would be attending from and make sure that that location was open to the public as well. And there were limited exceptions to this. For example, if you were active military, but otherwise that remote location had to be in the meeting notice and that location had to be open and available to the public. That specific requirement was removed. So now if a member wants to attend remotely, they may do so as long as the notice indicates members will be participating remotely and the meeting follows all the other requirements still in place. So members still must be seen or heard. One member still must be physically present at the regular meeting location, and all votes are conducted via roll call. It's just that the remote member's location is no longer required to be open to the public. Another note here is that this change is not required, so if a public body wishes to limit the use of these new changes, they can definitely consider changes to their bylaws or operating procedures. And as you'll see here, this provision went into effect May 24th. Okay, that is it for legislative changes. So now let's just turn to a few questions that the Data Practices Office has received in the past months that we want to highlight for a wider audience. Our first question is about data practice policies. So if an entity has no changes they need to make to their policies, do they have to update them annually? I got you on this one. If this question sounds familiar, it is. We had a similar, if not identical question from our July webinar last year, and that's just because it's a good reminder that August 1st is just around the corner. This is the statutory deadline for all entities subject to the Data Practices Act to update their policies. So as a reminder, Section 13.025 of the Data Practices Act requires all government entities to create, sorry about that, had a little coughing fit. All right. So as a reminder, Section 13.025 of the Data Practices Act, excuse me, requires all government entities to create and maintain policies regarding access to public data, as well as the rights of data subjects. So in other words, your entity needs to have a data access policy for members of the public and a policy describing data access and the rights of data subjects. So the law requires that these policies be reviewed and updated by August 1st of each year, or at any other times as necessary to reflect changes in staffing or your procedures. Excuse me. So if your entity has no changes in its policies from the last year, you should still take a look at your policies to ensure that contact information for all staff listed in the policy is accurate. Dating when your policy was last checked can help you track these accuracy checks and ensure compliance with the August 1st deadline. So the answer to the question is yes, please check your policy annually to make sure it's up to date. And then even if no changes are necessary, document that the policy was checked to ensure compliance with this, the section 13.025 requirements. If you need assistance creating a policy, our website has sample policies and a guidance worksheet to help you consider different factors as you update your policies. So visit our website and select the resources menu to find a page with example policies. Additionally, this time of year is a great time to see if your policies are easily accessible to the public, which is required by law. And one of the easiest ways to do this is by posting the policies on your entity's website. So if your entity hasn't posted the access policies online, that is definitely something we would encourage you to do. All right, next question. Can a government entity cite Minnesota Statute Section 13356 to redact all email addresses it maintains about individuals when responding to a data request? So Minnesota Statutes 13.356 contains a private classification. Specifically, it applies to telephone numbers, email addresses, and similar online account information that individuals submit to a government entity for notification purposes or as part of a subscription list for an entity's electronic periodic publications. So as an example, let's say that someone signs up for email alerts when there's a snow emergency in your city, or maybe they sign up for your entity's monthly newsletter. So in those instances, you would be maintaining the email address for notification purposes or as part of a subscription list, and the private classification in 13.356 would apply. But if you are maintaining the email for other reasons, say they are a vendor you work with, or this individual emailed your office to share information with you, then those email addresses are just presumptively public. So furthermore, the Data Practices Act doesn't contain a section that generally classifies all contact information of an individual as not public. So individuals' contact information like their names, home addresses, telephone numbers, or email addresses are just going to be presumptively public in most situations unless a specific provision within the Data Practices Act classifies the data as private or confidential. So as an example, if you maintain the personal email addresses of your employees, those would be private data under Minnesota Statute Section 13.43. Another example is if the emails are from correspondence sent to an elected official, then those emails would be private under Minnesota Statute Section 13.601. Other classifications may also apply, so please feel free to reach out if you would like to discuss the data that you maintain further. All right, moving on to our third question. Is a resignation letter submitted by an employee public data? So resignation letters are personnel data because the entity is maintaining the letter because the individual is or was an employee, volunteer, or independent contractor. And under Minnesota Statute Section 13.43, Subdivision 4, all personnel data are classified as private unless they are explicitly called out as public data in the statute. So Subdivision 2 of the section does state that the first and last dates of employment are public data. But public personnel data listed in Section 13.43 does not include resignation letters. So the answer here is that the resignation letters are private data on the employee and are not public data. But just an additional note here, excuse me, the resignation letter is private, but the fact that the fact that the employee resigned is also private, since that information is not, again, explicitly classified as public under Section 13.43. So as a result, if someone asks for a resignation letter, you could neither confirm nor deny that the resignation letter even exists, because that in of itself would be revealing private data. So in this instance, if someone requests it, I would just suggest providing the last date of their employment if their last day has already passed, and stating that any other data existed, that if any other data existed, excuse me, they would just be classified as private under Section 13.43. Okay, question 4, we go to body cameras. So a data subject asks whether they may bring someone with them who is not a data subject to inspect or view private body camera videos. Is this permissible? So under 13.825 subdivision 4B, only data subjects may access or view private or non-public body camera video in its unredacted format. This right does not extend to other individuals who are not data subjects. So those unredacted data on other individuals that the data subject may see are not data that that person can give informed consent for, right? However, if the data subject requests a copy of the body camera footage and all other data subjects are redacted, the requester can then share that redacted body camera video with anyone or provide informed consent to have someone else request that redacted copy. So this question did in the past raise another, which is whether a data subject may bring an interpreter with them to view unredacted body camera videos. The Data Practices Act does not address translation services, so there may be obligations outside of the Data Practices Act for government entities to provide translation services or access information or data in another language. If the government entity contracts with interpreters to provide access to information or data in other languages, the interpreter could be pulled into the entity for purposes of data practices as an independent contractor or employee, and the interpreter would be subject to the same requirements other government employees are in protecting not public government data. However, if a data subject wants to bring their own interpreter, the interpreter is likely functioning just as a member of the public and would need the written informed consent of other data subjects in the video, absence any other statutory authority or obligation to provide translation services in this way, which falls outside the scope of our authority. Okay. Question 5, we're going to stick with law enforcement data. So a member of the public requested an inactive investigative file. The file contains medical information. Can we release this data? So presuming we are talking about adult criminal records, any inactive criminal investigative data are classified as public data under Minnesota Statute Section 13.82 Subdivision 7. So we have public data, but other sections may restrict or classify release of this public data. So for example, if you have protected identities, such as a CSC victim, those data are protected. And another protection is health records received from a provider. So under the Minnesota Health Records Act and Minnesota Statute Section 144.293, health records received directly from a provider may not be released unless in certain instances as laid out in the Health Records Act. And public data requests are not one of the authorized reasons to disclose health records from a provider. So as a result, any health records in your inactive investigative file that were received directly from a provider would not be disclosed in response to a public data request. But keep in mind that these files may contain data with health information that were not received directly from a provider. So law enforcement agencies are not considered providers under the Health Records Act. And as a result, if a suspect, just told you about their medications or a witness disclosed their own health diagnosis, those would not be considered health records, and they would just be treated like other law enforcement data and would probably be public if inactive. So how your entity obtained that information will matter when it comes to disclosing it in response to a public data request. Okay, so that was all the updates and questions for today. We are more than happy to take a look at some of yours. Please remember to send them to all panelists so we can be sure to see them. Just a few reminders on this slide before we get started. The slide deck is available on our website and you can access the recording on our YouTube page in the next day or two. I am going to reshare the slides in just a moment as well, but remember again, if that doesn't work for you, you can just visit our webpage. Also, in just a moment, I'm going to be putting an evaluation in the polling panel. Before you leave today, if you could just fill that out and let us know how we did and what other topics you'd like to see in future webinars, that we can make sure, that these are helpful for you. We would really appreciate that. So you can watch out for that evaluation to appear as well. And now there may be silence as I share these slides and upload this poll and as we go through the questions. If we don't get to your question or if you have to hop off, please feel free to reach out to us using our contact information, which is right here, because we are always happy to answer questions outside of our webinar time as well. All right, again, just bear with us a moment while we get going on answering your questions. Thanks so much.
All right, I'm happy to hop in here first. And so we have a couple of questions about the new language in 13.03 subdivision 3, I believe, that paragraph G. And so with that, the new statutory language of suspending further requests, does this mean that if the individual does not collect copies that they cannot put in another request for the same data? I don't think so. I think the language simply addresses, hey, if nobody has picked up this data or paid for their copies, then you can suspend that request. It doesn't really address future requests or forthcoming requests going forward. So it's really taken as one at a time. But that may be an opportunity to simply say, hey, you're submitting a request for the same data. We've got all of this information prepared. Can you come and pick it up? That would probably be a good opportunity to speak with the requester. And then once we've fulfilled the request, we are not obligated to redo it again. Not quite. I think, or I know under the Data Practices Act, members of the public can request public data as many times as they wish. There's no limit on that. And so that language doesn't say, hey, you only get one opportunity to request public data over a certain period of time. If somebody asks for the meeting minutes from, let's say, July, and they pick those up, and then 3 weeks later they ask for the meeting minutes from July for your city council meeting, you've got to provide access to those data once again. And so it doesn't provide any, or that new language doesn't create any sort of limit on the number of times that folks can create public data. Rather, if you've got the data prepared and nobody comes in, picks it up within those 5 business days, then you can suspend any further response to that request if you're providing it on a rolling basis. And so the additional question here, under our reading of 13.03G, subdivision 3G, if the requester has not inspected data or collected copies in response to a request A, can the government entity suspend a response to subsequent request B for different data than A? So we're talking about 2 different requests here. The requester didn't, and your entity is working on both of them at the same time. If nobody comes and picks up the first batch of data for request A, can you stop work on request B? I don't think so. Really what the language talks about is responding to a request, not to requesters. And so if nobody picks up data from request A, I think then you have to provide the first batch of data under request B. Nobody picks that up, then you can suspend a request B at that point. And so you do need to treat these as individual requests. It's not designed to be broadly applied to requesters. I think that's the distinction that I would make there. But, internally, you could have policies or procedures to say, hey, we'll work on, one of your requests at a time and kind of order that, speak with the requester and coordinate with the requester to say, hey, do you want us to prioritize B over A? That might just be a conversation to have with the requester with your internal procedures. But again, this is just simply to suspend the request. Your policies can also have some further information about when you consider a request to be abandoned, and then you can move on to other work. So thanks.
Okay, we had a few questions about the changes to 13.825, the body camera statute. So I am just putting those up so you can read them. But essentially, for changes to 13.825, when sharing unredacted body worn camera data with a requester that could receive a crash report, what do we do if there was no report? If there was merely an exchange of information with no report, how do we handle that? Well, the changes to 13.825 say that individuals that are entitled to report under 169.09, a report that's required on under 169.09, can have access to the unredacted body camera video. So in doing that, they have to actually provide the report to you. So even if they're entitled but they don't have the report, they can't get access to the body camera data. They must give you the report when they make the request, and that's what allows them to get access. The other related question, I'm trying to find it under here, was when was the effective date, which was July 1. So it is effective now.
Okay, the next question I have here, I'm just making sure it's popping up. Can agencies decline written requests for summary data if the requester refuses to prepay for the cost of creating the data? Is there a customary hourly rate for copying and redacting data? This is a great question. So just to get everybody on the same page, section 13.05, subdivision 7 talks about the preparation of summary data. And this is where requesters can ask a government entity to prepare summary data out of private or confidential data. And there's some requirements related to that. So again, that's 13.05, subdivision 7. But yeah, there's also some additional language in the Minnesota Administrative Rules, and I would point you to Rule 1205.070 700. Again, that's 1205.0700, which also is the administrative rules related to accessing summary data. That's really provides a lot of good explanations about how to handle summary data requests. And under subpart 7, it does talk a lot about paying for the preparation of summary data, as well as collecting funds prior to preparing summary data. And so, yeah, if a requester refuses to prepay for the costs of creating the data, I think you can basically say, hey, we're not proceeding with the request per the Minnesota rules, as it's explained there, that you can collect any funds necessary to reimburse yourself for the preparation of supplying that data. And so that's perfectly, I think, allowed within the administrative rules. As it comes for a customary hourly rate, again, that subpart 7 provides some guidance on how to calculate any rates. The rates do need to be reasonable, and so there's not a standard number that we can give you. It's probably going to depend on the amount and the nature of the summary data request. But yeah, take a look again at 1205.0700 for some of that guidance on what you can charge for the preparation of summary data.
Thanks, Casey. I can hop in with the next one. So we did have a question. Oh, and let me just, we did have a question about the changes to the open meeting law that I discussed. And so this question asks, can the city council adopt tighter restrictions surrounding interactive technology use for their own body? And they think the answer is yes. And I would agree with that. The changes to 13D.02 regarding interactive technology, using interactive technology for meetings, or what we call remote meetings, sets a bare minimum, right? It's also permissive. So if you wanted to do something, if you wanted to be a little bit more restrictive on your use of interactive technology, I think you can do so. I would encourage that public body to look at its own operating procedures and policies and clearly state how they're going to go about using interactive technology and performing those remote meetings. But should they choose to do so, at the bare minimum, they have to meet those requirements in 13D.02. So hopefully that's helpful.
There were a couple questions about the judicial safety law related to property records. And so I just want to provide as much information as we have about how that's going to work. I think we're going to see how it works. One is a question about whether it would relate to maybe data that a city has about building permits or septic records or things like that. It definitely could. The definition is broad enough. But again, remember that those judicial officials have to provide you with a form that the judicial branch is currently creating. So they'll provide you with that form. I believe it also allows the changes allows some fees for those. So take a look at the law. Again, it's very new in terms of implementation. There are going to be a lot of questions, and we'll work with you as best we can to try to understand and be consistent. The other question is about who this new judicial safety property provisions, who does it apply to, is what I'm trying to say. And the definition in 480.40 has a list of folks, and it includes judges, current, former, and all the various levels of the judicial branch. But it also includes employees of the executive branch courts, employees of the judicial branch, so staff, clerks, etc. But the property record piece of this only applies to those current and former judges listed in 480.40, not the additional staff for either the judicial branch or the executive branch courts. So that is a limitation specific to the property records. The definition is much broader for all of the other types of data that you may have about a judicial official under that definition.
Okay, another question that we have here. Since we can't release even the fact that an employee resigned, how do we go about posting the position before the employee has left, especially if someone gives a long notice? I don't think, the 1343 affects, the process to post an open position or a future open position. Certainly I would encourage you to talk with your HR staff or your HR team, or if you're a small agency, I imagine you might be working with a smart team. So talk with them about those aspects. But, the fact that you're posting a position, maybe before someone retires sometime in the future, or it's someone that is planning on leaving, that posting doesn't necessarily reveal who might be leaving, although there might be some titles that say, hey, it might be a particular person, a director. It's possible that you just might be hiring someone new, or that person might be working in addition to that other director or that specific position as you're getting up to speed. So, I don't think that would necessarily affect your ability to post. Of course, if you're directly asked, why did Casey Carmody leave the agency, then that would be private personnel data. So I think you've got enough room there to still post the position without revealing any private personnel data.
Thank you, everyone. I do see that we are at time here, and I want to make sure you have time for everything else you need to do. If we were not able to get to your question, we will follow up and make sure that we can provide information related to your question. So thank you for asking it, and we will be following up. And of course, if questions pop up after today, please feel free to reach out to us. All of this information on the slide, we are more than happy to discuss these legislative changes with you or other questions that may pop up. So please feel free to reach out at any time. If you have not filled out the poll, I encourage you to do so. That information really helps us as we plan future webinars. And besides that, thank you for your time and have a wonderful day.